Hello, this is Matt on the Moon Family Sedan channel, and this is Ripple's final stand, kind of the end of an era. They filed their final brief in the SEC v. Ripple case. Can you believe it? It's been almost 2 freaking years at this point, and Ripple finally filed its last brief. And this brief is a reply brief to the SEC's request for a favorable motion from the judge in terms of summary judgment. Now, I'll tell you, so this thing, here I got some dead trees with my little Moon Family Sedan fingers right now. This thing was 65 pages, and the brief itself was 56, once you take out like the table of contents and case law, stuff like that, that was cited. So here's what I'm going to do. I'm gonna cover it the way that I normally do it, but I'm going to break this content up into a minimum of 2 videos. I think I can probably get by with 2. If I find that it starts going longer as I'm recording, because I never know for sure, then I reserve the right to extend it into a 3rd video. I think I can get by with just 2 though. And I'll tell you this at the outset here. I don't like breaking content up if it's a single subject into separate videos typically, but that's only if it kind of ruins the flow. Like if you need full context in one sitting to understand something, that's when I'm like, okay, if this video needs to be 30 minutes, 40 minutes, 50 minutes, so be it. And I've done that. There are a handful of videos that are on the longer end. I've had videos that are close to an hour. They're just not that common. But for something like this, even though it's technically one topic, there are so many standalone points throughout this. Pretty much all the points are standalone points that I have no reservations about chopping this thing up into at least a couple of videos. And I know that that's what most people like. Some of you, I'm sure, like the longer videos, but most people, I can tell based on feedback that I've received, prefer, whether it's a 10-minute or 15 or 20-minute video, 25 minutes. But when you start getting into the 40, 45, 50-minute video, like videos, fewer people are interested in that. So I'm just, I'm taking the feedback there. So if I can chop up a video, then I'm going to do it. But look, I'll tell you this, and we'll see how much gets covered in this first video versus the second video. But there's a lot that's happened since Ripple filed their motion for summary judgment, which I believe was the last legal brief that we saw from them, right? And so we had the conclusion of the library case. We also had 2 amicus briefs filed in favor of the SEC. Now, obviously, all the rest of them were in favor of Ripple. There was something like 13 in favor, 2 were kind of neutral, and then 2 for the SEC. And so Ripple actually took this opportunity to talk about all that. They talked about library as well as those amicus briefs. And most of what's going on here is they're ripping to shreds the SEC's motion for summary judgment. So there are big chunks of this where if I feel like it's too much, just the same stuff that we've been talking about forever, I'm going to gloss over some of that. Like, so for instance, the aspects of the Howey test, but the portions where they're talking about why the SEC is wrong based on like what they argued in their motion for summary judgment, some of this is worded so strongly and so profoundly, it would be a disservice to not inform you of all of it. So this is absolutely glorious. I think you guys are going to really enjoy this one. This is one of my favorite things I've actually seen from Ripple in the last 2 years. It's just, now that we've got all the publicly available information we could possibly have to this point, I mean, gosh, and we see what's on the table. The degree to which the SEC is living in like some sort of fantasy absurd land, it could not be more clear. They're just, and Ripple really hammers the point home. And the asshats at the SEC, they made a bunch of straw man arguments. It's just despicable stuff. So we're going to break this all down here. But before going further, I do want to be clear, I do not have a legal or financial background of any kind. I should not, I forgot what the hell I'm saying. I'm tired. To be honest with you guys, it is 3:50 a.m. and it took me like 2 hours to go through this damn thing, including taking notes. And you got like a bunch of sticky tabs and stuff. I'm a little tired right now. Let me try my little disclaimer here again. Just to be clear, I do not have a legal or financial background of any kind. You should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. A shout out and credit to James K. Filan, a member of the XRP community, for sharing this reply brief. Also want to thank John Deaton's Crypto Law Organization for sharing this document as well. And let me start by sharing with you some perspective and some comments from Stuart Alderati, Brad Garlinghouse, and a few lawyers from the XRP community. So here is what Stuart Alderati, Ripple's general counsel, had to say. Ripple's reply brief is public. You can view it here. And then he links to James Filan, his tweet. Then he says, "This is our final submission where we ask the court to grant judgment in our favor. After 2 long years, Ripple is proud of the defense we've mounted on behalf of the entire crypto industry. We have always played it straight with the court. Can't say the same for our adversary." Isn't that the truth? And Attorney Deaton highlighted as much. He actually retweeted that from Stuart Alderati, and Attorney Deaton wrote, "Let me translate what Ripple's general counsel is tactfully saying. In the 2 years that Ripple has defended itself versus the SEC's massive overreach, with so much on the line, the Ripple team maintained a faithful allegiance to the law, something the judge herself said the SEC lacked." Yeah, that's quite apparent. My favorite line from either of the judges in this case, it came from Judge Netburn, when she stated that the SEC was not acting in faithful allegiance to the law. That, I don't know if that's an exact quote, but it's something to that effect. That was my favorite, because she really just raked him over the coals, right? And then there was this from Ripple CEO Brad Garlinghouse. Brad said, "I said it on day one, we will aggressively fight to get clear rules for the entire industry in the United States. Congrats to all of Team Ripple for getting us to this point. Ripple stood strong and withstood the SEC's onslaught. I look forward to being on the right side of justice." And then there was this from Attorney Jeremy Hogan. He said, "Are you a touch sad also? Ripple's final brief. I'm going to miss legal writing this good." Okay, well, fair enough that it's fantastic legal writing. Like, it doesn't get more top shelf than the defense that Ripple ended up hiring, the lawyers that they have. But I'm ready for it to be over. Just personally, I'm ready for it to be over. Can we just let this end? My God, almost 2 freaking years. But no, I get what Attorney Hogan's saying there. And then also, somebody named Light XRP was asking him about the Hinman emails. And I will note, as Attorney Hogan said also in this tweet, that the emails actually are cited once. So I'm going to get to that. That might be in the next video. It depends on how far I get into this thing, because again, like I said, I'm going to chop it up. If it's not in this video, it's going to be in the next one. But that was actually brought up. That's another thing, development that occurred, and this is the first time in a legal brief that it's been touched upon by Ripple's attorneys, which I found very interesting. And then there was this from Attorney Deaton. Attorney Deaton also wrote, "In its reply, Ripple also cited twice to the nearly 3,000 XRP affidavits that we submitted. This is in addition to the 8 times Ripple cited to XRP holder affidavits in its opposition papers." Yeah, and it was nice to see that they cite throughout this a number of the amicus briefs that were filed, and there are so many reasons that's important, especially as it applies to prongs of the Howey test, and we'll go through it, but Ripple points that out in great detail. And then there was also this from Attorney Bill Morgan, member of the XRP community. He said, "Thanks, James. Good to see Ripple rely on the Paradigm amicus brief and giving me something for my obsession that common enterprise is a real weakness for the SEC. Post-sale rights and obligations are necessary to create a common enterprise. There are none between Ripple and XRP holders." Yeah, exactly. And Ripple also points out on more than one occasion in this thing that even the SEC hasn't been able to identify a common enterprise. Folks, couldn't even identify what the common enterprise is. How the hell, SEC asshats, do you think that Howey can apply here and you can make a compelling case if you can't even identify what that prong of the Howey test is? My gosh. Really grinds my gears, folks, but in we go. So here's the document, and I'll try to remember to scroll down as I go through this thing here. So let me jump ahead here. I almost said fast forward. That makes no damn sense. This is not a streaming service or a video cassette. Remember when you had to rewind videos? Man, I'm old. 39 years old. I'm starting to sound old time. Well, I'll tell you what, you young ones listening out there, you get to my age, stuff that you think is normal right now. Yeah, check to the people who in the future will be your age, and you're gonna be old geezer at that point compared to them from their perspective. So now we go down to, if you look at the top number, it'd be 10 out of 65, or technically page 1, which is the preliminary statements here. So let me just keep on scroll. Oh, and I passed it. It's this little thing I do on the Moon Family Sedan channel. All right, so here we go. Preliminary statement. And I jump around a little bit, but I'm starting right here. The SEC cannot show that any offer or sale of XRP, much less every one from 2013 to 2020, as it alleges and bears the burden to demonstrate, was an offer or sale of an investment contract and therefore a security under the federal securities laws. And then I'm jumping down to right here. And they say every pre-Howey case finding an investment contract, Howey itself, and every Supreme Court and Second Circuit case following Howey involved one or more contracts imposing post-sale rights and obligations on the party. So here I want to note, Ripple is in the Second Circuit, not the First Circuit like Library, for example. So, different case law applies. If Ripple loses this, it would be a first of its kind loss, because you're talking about there's literally no contract, and in this circuit there is no example of case law that would make the SEC's arguments make sense. They're like zero, literally zero. And Ripple points out as we go through this, even the SEC couldn't point to it because it doesn't freaking exist. There's a little secret. But they just argue crappy because reasons, throwing spaghetti at a wall and seeing how much of it sticks. That's pretty much it. It grinds my gears. All right, now down to the next page. I'm going to start to write about here. Okay, reads as follows. Because all XRP is fungible, the SEC's, turning page, the SEC's position would lead to a completely unworkable result in which purchasers and sellers would have no way of knowing whether they were transacting in registered or unregistered XRP. So the point I wanted to make with this, and I don't recall, maybe they talked about this before, I just don't recall it off the top of my head, but consider this. If some XRP sales represent investment contracts and initially illegal securities transactions, right? If some XRP sales represent investment contracts, does that XRP forever need to be kept separate from all other XRP? And see here, this is where the rub is. It's like, you cannot, on secondary markets, tell where the XRP originated. I mean, like, technically, yes, you can look at the blockchain, it's public, you can see where the transactions flow from, but it's not like it's got everybody's first and last name on it, or necessarily even business names. Like, you can choose to attach information to transactions, but I'm just saying, there's no realistic way that people can tell where what the XRP has been through to that point, because it's fungible. It's all fungible. But some of the XRP would be need to be registered, and other XRP would not. It's all on the same blockchain. How do you even you can't track that? And the SEC just pretends like that's not even an issue. Completely ridiculous. All right, let me scroll down to the next page now. Going to page number 4 here. I'm going to jump in right here for those of you looking on the screen. Sorry, one sec. I know it slows me down a little bit, and that's probably annoying for people that are just listening, but I try to, appease everybody, because I know a lot of people just listen. That's usually how I treat YouTube channels, when I can anyway. But I know that there's some people that look at the screen, so I'm just trying to do what I can here. So anyway, it reads as follows. There can be no reasonable expectation of profits from others' efforts when market forces, rather than the alleged promoter, determine an asset's value. And so pause, think about that. That's a prong of the Howey test, expectation of profits. So how do you have expectation of profits when the price of XRP here specifically is reliant upon market forces having nothing to do with Ripple's efforts? How do you even make that connection? And then they write, here, the SEC's own expert concedes that from mid-2018 onward, Bitcoin and Ether returns can explain as much as 90% of XRP returns, end quote. The SEC offers no serious response and simply denies that the cases say what they are, I'm sorry, I'm a little tired. The SEC offers no serious response and simply denies that the cases say what they say in establishing this legal rule. Exactly. It's just another hole in the argument. It doesn't make any damn sense. Now let me scroll to the bottom of this page and jump in right here. For the SEC to prevail in its opposition, the court would have to endorse the SEC's theory that there can be an investment contract without any contract, without any investor rights, and without any issuer obligations. It would have to endorse the SEC's theory that there can be a common enterprise even if the SEC cannot say what the enterprise is or prove any of the elements that define such enterprise. Let's just pause here and think about this. This is one of the things where I read that and I was like, here, Ripple. I was like, I was getting fired up a bit. I was like, yes, exactly. It's that stupid. Can you imagine Judge Torres actually ruling in favor of the SEC when the SEC says there's a common enterprise, but in its arguments cannot say what that the common enterprise is, and that's a requirement to pass the Howey test, meaning something's a security if it passes the Howey test? Can you imagine Judge Torres actually being like, yeah, we're just not going to worry about what the law says? I mean, I guess it's possible, but come on. Like, this is completely absurd here. Yeah, we're just not worried about that little baby boo aspect of the law. It doesn't matter. We're the SEC. Okay. All right, you pricks. That reads as follows. And it would have to endorse the SEC's theory that purchasers could reasonably have expected profits from Ripple's efforts, even though Ripple never promised to make any efforts, even though it expressly disavowed any obligation to do so, and even though profits were overwhelmingly due not to Ripple's efforts, but to market forces. The court would also have to conclude that all the amici that have expressly said they did not join a common enterprise or expect profits from Ripple's efforts are wrong about their own beliefs and actions. I love that one when I read that. Think about that. Amici, like, what, are they just lying to the judge about what they're doing in their business models? That's why, again, this is like some of the most powerful stuff in this whole thing right out of the gate here in the preliminary statement, because they just do a great job summing it up. And then they say, here we go. The SEC's position boils down to a view that anytime someone buys an asset hoping to make money and the seller's interests are even partly aligned with the buyer's, it is a security subject to registration. That is not the law, even if the seller uses the sales proceeds to run its business. If Congress wants to expand the securities laws that way, it can do so, but this court should not. Now that, I found that to be exceedingly powerful. Now let me jump on to, at the bottom page, if you look at the bottom page number, it would be page 8. Let me scroll on down here. Yeah, here we go. I'm going to jump in right here. The SEC argues against even the basic requirement that a contract must exist for an investment contract to exist, which always sounds silly to me, but they argue that. It relies on Howey's use of the phrase, quote, contract, transaction, or scheme, end quote. But, as defendants explained in their motion, that language merely directs courts to look beyond the four corners of the contract to evaluate the entire relationship between the parties. No court has ever interpreted that phrase to mean that a contract is completely unnecessary. The SEC responds that the Supreme Court did mean to eliminate the requirement that any contract exists, but it cites nothing to support that interpretation. So let me translate that for you. The SEC is saying something that they completely fabricated. They just made it up. You know, because again, they're asserting that the SEC meant to not have an actual contract be a requirement for part of this. They just say that. They assert it as true. That's what the Supreme Court meant. And then provide no evidence for it. Do they think the judge is stupid enough to just believe that? Because I don't. I sure as hell don't think that. They're just making up crap. You know, and again, you know, no, as I say here, no court has ever interpreted that phrase to mean that a contract is completely unnecessary. No court in history. This is what we're working with, folks. And they know they're lying. They're lying through their teeth. They're absolutely lying through their teeth, and they don't care. They have no shame. It's going down to page... Did I skip one? Wait a minute. I think we're going down to page 10. Wasn't I just on 8? Oh, yeah. No, we're good. Yeah, we need to go down to page 10. All right. Scroll right on down to the bottom right here. Jump in right there. The SEC contends that contractual rights and obligations that satisfy the Howey test are unnecessary as long as Ripple conducted what the SEC calls a quote, a capital raise through selling XRP, end quote. But it cites no authority to support its sweeping contention that if a business funds its operations, even in part, by selling an asset, that asset must be a security. And nor could it. The Securities Act offers a specific definition of securities, and it is not, as the SEC suggests, any assets a company sells to raise capital. It also defies common sense. All business revenue that is not distributed to equity holders goes toward operations in some manner. So the SEC's position would transform every asset sale into a security. If Ford uses revenue from car sales to build a new assembly plant, neither its cars nor its sales of cars thereby become securities. Likewise, for computers from IBM, oil from Chevron, gold from Newmont, or shoes from Nike, even if the buyer hopes to turn a profit. And so here you go. This is the SEC literally just making crap up again. It's bogus arguments, hoping to trick the judge. And I guess the only way that could have been possible is if they didn't have sufficient pushback. Like, say Ripple had like a really crappy legal team, which they sure as hell don't. They have a great legal team. And then the judge also was unaware of certain aspects of what's going on here. And it's just like, oh, well, that sounds convincing. And Ripple didn't have a... That's about the only way. That's not what's happening. I can't imagine Judge Torres actually falling for this. And so again, if XRP is a security here, then why isn't a Ford Mustang or a Ford Explorer, why aren't those vehicles securities? What the hell's the difference? And so the SEC is setting a new standard, and it's an absurd standard. Could not be more freaking obvious. All right, I'm going to break it up here since we're over 20 minutes already. There's a good chance I can probably, like I said at the outset of this video, get through this in just 2 videos. If not, I reserve the right for a 3rd video. But they can flow in any order. I promise you it's not going to matter. These are like, you can see, like, even the points that I made here, I could have read those to you in any order. It does not matter. So I'm not worried about that at all. Isn't that cool stuff, though? So some of the best stuff, it's going to be in my very next video. It's going to be a continuation of this. So we've got the Hinman email coming up. We've got stuff having to do with library and even more shenanigans that the SEC stated that Ripple had to fight back against. So some of the meatiest bits yet ahead. And I'm going to be recording that video right after I finish recording this. Well, I'll start uploading this, and then I'm going to hit record on the next video. So I don't know exactly when, but not long after this video goes live, the next one's going to be live. Hopefully within the an hour or 2 afterwards is what I'm aiming for. We'll see, but you won't have to wait long for it. But I love reading through this, and again, I really was looking forward to once I realized what was in this thing, looking forward to seeing what they had to say about the amicus briefs in favor of the SEC and what they say about library. And Ripple definitely did not disappoint, so that'll be in the next video. But I'll go ahead and wrap up here. I am not a financial advisor. You should not buy or sell anything because of anything that I say or write. That would be a very, very, very bad idea. Until next time, to the Moon Family Sedan.